Chinese cybersecurity law has been implemented on June 1, so we're now about 6 months in. As a refresher, it was developed because China had basically no legal framework for protecting data, personal data, important data. They had no cybersecurity regulations. Their state-owned sector, their government agencies were basically employing zero to little information security, cybersecurity practices. So there was a real need for the Chinese government to develop a framework to protect some of their critical industries and personal information. So it's understandable why it was implemented. In fact, it's really a global phenomenon, what's happening with cybersecurity rules, data privacy rules. China's not the first country to do so, and it certainly won't be the last country either. The first thing to come out was the law itself. And subsequently, we've seen a bunch of implementing regulations that are kind of filling in the gaps. The law is quite vague, it's quite broad. It covers, we call it the omnibus law. It covers issues ranging from cybersecurity to data privacy to data protection to content. And now we're seeing the implementing regulations filling in the gap. And they're coming out, and they will continue to come out probably for the next year and a half. The head agency in charge of the cybersecurity law is the Cyberspace Administration of China, CAC. CAC has stipulated that the industry regulators are supposed to develop industry-specific regulations. So that would be the People's Bank of China, the China Food and Drug Agency, the Ministry of Information and Industry Technology. They're all now responsible for developing their own industry-specific cybersecurity regulations, which makes sense because they will know the actual issues facing their industries. So we expect within the next 6 months to a year, a whole additional flurry of activity that's specific to industry. Another key point is that we've seen over the past 6 months is the emergence of the police, the Ministry of Public Security, as a key enforcer of the cybersecurity law. They announced a campaign back in March that they were going to go meet with party, government, industry to review their cybersecurity situation. And certainly they've been issuing thousands of what they're calling rectification notices. Anecdotally, they have been approaching foreign companies as well. The cybersecurity law has a data component, and that is that critical information infrastructure has to localize personal and important data to China. We've gotten more details in the implementing regulations, what's considered important data. But from the personal standpoint, personal data is any data that can identify a natural person either by itself or with another piece of data. I won't go into too much details about the personal aspect, but for important data, there's been an implementing regulation that has come out since. It's still in draft form. It's expected to come out in finalized version by the end of the year, although that's not guaranteed. That has listed 27 or so industries and what's considered important data to them. Cyberspace administration officials have said that important data is not data that's important to business, but data that's important to the government. So it is data that they consider from a national security standpoint to be sensitive. And if you read through the appendix that lists what is important data for these industries, it's certainly data that the Chinese government would consider sensitive. For example, for the chemical industry, they've listed data about where the chemical factories are located or their layout, and this is directly linked to the huge chemical factory blast in Tianjin. I highly recommend companies go and read that appendix so you can start getting your own sense if any data that you have as a company could be considered sensitive from a national security view in the eyes of the Chinese government, because that data is now subjected to cross-border data flow regulations. It's possible that that data would have to be reviewed before it gets sent out of China by an industry regulator. I think in recognition of the potential impact on business because of the cross-border data flow guidelines and regulations, that the government has given a grace period for companies to be compliant until the end of 2018, so December 31st, 2018. The actual finalized version of the cross-border data flow guidelines is supposed to be out by the end of this year. Certainly if they've given a grace period only until 2018, that they would have this out soon. So we're hoping by the end of the year that we're going to see a finalized draft. The grace period of a year and a half is recognition that it will take companies a long time to actually sort out where their data is, what kind of data they have, where is it stored, and then if it's potentially not compliant, start preparing for localization. This will take several months. Companies should therefore start, if they haven't started doing this process, should start now. Basically, you need to map out the data. What kind of data do you have? Where is it stored? And Is it flowing from China to Canada or even from Canada to China? If you do have so-called important data that's potentially sensitive from a national security standpoint, we're recommending that you seriously consider localization, because this is a priority of the administration. This law is heavily influenced by national security considerations, and frankly, it's not going away. A concrete example would be a Canadian company that is receiving data from China, from a Chinese client, a Chinese customer, analyzing that data and then sending it back. That's considered a cross-border data flow in the eyes of the government. And the question then for that company would be, is that data that you're receiving from China, is that data that's regulated now because of the cybersecurity law? So is it either important data or personal data? Now, personal data is a bit easier to understand. So important data, this is tricky. As I mentioned before, there is a guideline that kind of has spelled out for various industries what's considered important data. So that's a really good starting point to see if anything you have might be considered important. To make plans for localization is tricky. It's going to require having a server here in China. I think you're going to have to require to have presence here in China, frankly, too, because even having a piece of the Chinese cloud, if you're looking at that data, even though it's stored in China, if you're looking at that data from Canada, that's also considered a cross-border data transfer flow. That's not alleviating their national security concerns that a foreigner is looking at that data, which is considered important. It's going to be costly, frankly, for some companies to actually have to be compliant in this respect. The Chinese government is aware of that. Frankly, their answer is that not that they don't care, but this is a priority for them and that this is moving forward.